an existing mortgage or a purchase money mortgage or something, we're going to talk about those different things, and there are provisions that come up for them. But whatever the amount of that financing is, that is not cash out of the buyer's pocket that the buyer will come up with on his own without borrowing it on a mortgage on the property, that's what goes in there. And if you're a seller and the buyer's saying it's all cash, you want the word none written in there. In huge letters, N-A, none. There's not going to be any financing. All cash. Did you have a question? I'm sorry.
Yeah. Is there like a rule of thumb for percentages of deposits in commercial versus residential?
Meaning how much should it be?
Yeah, I mean, if it's a $10 million building, I mean, do you put
in the old days,
$1 million deposit on commercial, or?
I doubt it. A $10 million building, $1 million deposit, I doubt it. Under the old, however, I was about to say, under the old rules, under the old days, traditionally a deposit was 10%.
It's like one.
10%. Now, if that's a $12,000 house, that kind of makes sense. If it's a $20 million property, now nobody's going to put down $2 million. They're not going to tie up that amount of cash for that long a time. Here's how it normally happens in a deal. Normally, there's a very small initial deposit of how much loose cash does the buyer have laying around in his account right now. Sometimes it's $100. Sometimes it's $500 or $1,000. But there will quickly follow an additional deposit of a somewhat significant amount. They give them time to sell a few stocks. They give them time to liquidate a CD, to come up with some more liquid cash. In big commercial deals today, you rarely see $1 million deposit. You see it if the seller is demanding it, of course. Sometimes the buyer's willing to do it, and sometimes the buyer's just not. And sometimes he doesn't have it. But I would say to you that in the old days it was 10%, and it's gone down and down and down and down as we go forward. And it turns on not only the financial strength of the parties, but the bargaining strength of the parties. Is the seller in a strong enough position that he can demand it and say, I've got 6 offers in front of me here, and I want 10%, and if you can't do it, get out of the way, I'm going to the next guy. You may have to, but there is no rule of thumb. There's another reason that realtors would like the deposit. Realtors would like the deposit to be larger for 2 reasons. We're going to talk about the second one in a moment. But realtors would like the more money down, the more likely the parties are to really mean it and close. Because a realtor wants there to be a closing. The other reason is you're going to see later that under some circumstances the realtor gets half the deposit if the buyer forfeits it. And half a big is bigger than half a little. But and I don't say this to be disparaging of realtors. There are good reasons in a deal to have a deposit. It's to show the buyer really means it. It's good faith, earnest money. I'm serious here. I really want to buy your property. And sometimes if a buyer is trying to impress a seller, he'll make a big old deposit. But as long as he's got all kind of rights under the contract to get it back, it's kind of just for show. And as you're going to see, there are all kinds of contingencies and things that are ways the buyer can get a deposit back anyway. So sometimes it doesn't mean a hell of a lot. Sometimes you can knock a seller out with a 10% deposit, but if you got 3 or 4 back doors in the deal to get out and get it back, it was just for show. Okay. And then obviously down at the bottom here is about F. Other is other, whatever else may be going on here. But F is balance to close. And all that is add up all the stuff above and subtract it from the purchase price, and that's the balance. And what it really says is how much money you're going to have to bring to the table, buyer, as it says, plus or minus adjustments. And it goes ahead and tries to tell the buyer right now, right up front here, and it's going to have to be in good money. Cashier's check, but even they are now being rarely accepted. Just about all deals are done today on wire transfers. because that's just about the only thing you can trust nowadays. A transfer of federal wire funds from bank to bank into your account, that's about the only thing worth relying on. We see so many fake cashier's checks now. Counterfeiters are just as good at printing up cashier's checks as they are printing up $100 bills. And oh, they look great. Cashier's check of the First National Bank of Omaha. There may not even be one. But boy, the check looks really good, and it's got all this raised print and the stamp seal and colors, and those are great, you know. And the guy just printed it up. But checks are used for deposits. Not always, but usually used for deposits. But we're talking about the money at closing. Because at the closing, seller's going to hand over the deed, you're going to record a deed, and it sure is a bummer to find out later that the check was no good. So we want normally wired money. And most contracts you'll see today will cross out this cashier's or official bank check and say wire transfer only. All right. We talked about setting a time for acceptance, and here it is. Line 21, section 3. Unless this offer is signed by the seller and buyer and an executed copy delivered to all the parties on or before blank date, this offer will be withdrawn and the buyer's deposit will be returned. So this is, again, this contemplates contract being signed first by the buyer. 9 times out of 10 it is, but not always. But usually this is an offer from the buyer to the seller saying, I'm offering to buy your property for such and such a price. Do you accept? This is how long the offer is outstanding. When this is trying to, try to put a back date on it. Try to make the seller do it or don't do it. Go ahead and tell me. Are you selling it to me or aren't you? Give me an answer. Don't sit on it for 3 weeks and shop the deal with 4 or 5 other people. And that's what you don't want a seller doing. You don't want to send a written offer to a seller and give him time to go ask 7 or 8 people. Can you beat this? This guy's offering me this. Can you do better than this? And shop your contract around. Shorten the fuse. Give him enough time to reasonably consider it, but not too much time. And people say, don't let it go over a weekend. It's old talk, but I mean, sometimes it has to. Sometimes the guy's in Europe, and it has to, but you want to put a deadline. Interestingly, this goes on to say the time for acceptance of any counteroffer will be 3 days from the day the counteroffer is delivered. What they're trying to avoid here is, it used to be when you'd mark up a contract and it said a deadline for acceptance such a date, you had to not only change the price, but then you had to go down there and change that acceptance date. And every time you changed the price, each guy would change in the acceptance date to give this guy 3 days and then give that guy 3 days. So what we're saying here, at least built into this form, which is good, is if you make a counteroffer, it's good for 3 days. That's built in. All right. Important bold print in the middle here is the effective date of the contract is the date on which basically everybody has signed it and everybody has initialed all the changes and everybody has agreed to everything and the last guy has done the last event. The point is, and the contract doesn't become effective until then, but it's usually not the day the contract was first drawn up and presented. It's usually a ways down the road, and sometimes it's hard to figure out what that day is. But it's an important date because you're going to see as we go forward, there are a lot of time periods in this contract. And time periods are measured from the effective date. So it's important to know what that date is. And if the contract has been countered back and forth between the parties 3 or 4 times, and finally they've both initialed that final price that they've agreed upon, unfortunately they usually don't put the date. And then they send the contract to their lawyers, and the lawyers say, well, what's the date? What are we going to measure these time periods from? So you want to try to nail that down. What is the final date upon which the final act of offer or acceptance is completed so that we have a final deal? Because we're going to measure the time periods from there. And then this contract, to the good, says time periods are going to be measured in calendar days. There are a bunch of old forms floating around. They'll just fool the hell out of you. and they bury this. There's a FAR contract form. This Florida Association of Realtors has a vacant land contract floating around. At the bottom of page 4, it says, we're going to use business days. So you go right in here, 60 days for the inspection period. And damn, that turns out to be 90 days because it's business days. 60 business days is 12 weeks. That's 3 months. That's 90 days. But it sure looks like 60 days. But it's 90 days if you say business days. So this contract, to eliminate that, is good. And it says when we talk about days, we're talking about calendar days. And it goes on to say, unless it's a 2-day period, in which case we mean business days, because of course we don't mean Saturday and Sunday. And then it says excluding holidays and all that kind of stuff. That all that means is we don't exclude them from the computation of days. It means if we end on a Saturday, it's the next Monday. If we end on a Sunday, it's the next Monday. But we do count them. When we say calendar days, we mean every day. And then a very important provision in bold print here, time is of the essence of this contract. That's hugely important. If you don't have that in a contract somewhere, that means you cannot enforce in court deadlines. You've got to have that provision. It can hurt you. It can help you. Depends on which side you're on. Yes, sir.
If it's not said in the contract whether it's calendar or business days, is it calendar days?
I don't know. I would suggest that we would presume that it is, but I just don't know. I think it would be calendar days. I can't imagine a court construing it otherwise, but I've never seen a case on that.
Repeat what you said on time is of the essence, please.
I'm sorry?
Repeat what you said on time is of the essence, please.
It's important in order to be able to enforce timetables. If you don't say time is of the essence and somebody was required to close in 60 days, if they closed in 70 days, you can't do anything about it. You can't claim damages for that extra 10 days.
Why not?
You can't default them on the 60th day because they haven't closed if you didn't have time as of the essence.
But you gave them a
default
deadline.
in a reasonable time thereafter. But the point is, the courts have said, unless you say that, we are not going to say somebody is in default for not performing by the exact deadline set forth in the contract. We will construe that to be a reasonable period of time thereafter.
Wow.
Okay. Now, closing date and location. Put a real date in here. Put a date. Put February 12th, 2015. That's what I'm saying to you. And for God's sake, look at your calendar and see whether that's Saturday or Sunday or New Year's Day or, you know. Jesus, a number of these things that you see on a Sunday closing and everybody goes, yeah, you know. But the point is, we don't get to use that time period clause up above here that says that any period of time that ended on a Saturday or Sunday continues to the next. It wasn't a period of time. You picked a day. So look at your calendar when you do that. And that gets crossed out too. Just like people cross out, you know, prices and stuff, they cross out the closing date. No, I'm not going to be ready in 30 days. I want 40 days, 60 days. Sometimes people put in there 60 days. And that's going to mean from that effective date. And then it's going to mean calendar days in this contract. And it's going to mean if that happens to fall on a Saturday or Sunday, well, that's great. You've got a built-in clause here that says we extend to the next business day. But if you picked a hard date, you don't get to have the clause that says it carries over. Theoretically, you're supposed to close that day. And most people worry about that enough. If it says time is of the essence, and if somebody picked a Sunday in there, most lawyers will tell you to close the Friday before. And most lawyers are not going to be willing to close it on Sunday. And the biggest reason is because we wire monies. The lawyers don't like to close deals and big deals anymore on Fridays either. Because wire transfers get sat on over the weekend. Wire transfers are a transfer from the Fed from bank to bank. So buyer's bank instructs the Federal Reserve in Atlanta to wire some money to the seller's bank. And banks love to delay those things because they love to earn the float on the money for 3 more days. So if you send a wire on Friday, it probably ain't gonna get there till Monday, because the bank you instructed to do it may or may not do it, or some other, excuse me, some other bank is gonna sit on it, or the bank that received the money is not gonna tell you they received it. They're not gonna tell you about it till Monday, but they'll earn the float from the Fed on it since Friday. So Fridays are not good days for closing. With wire transfers. One interesting line that's important here in Florida that you need to be aware of, and we're going to bring up this concept a couple of times here because of hurricanes, and we're still in hurricane season. You know what? I bet we're not as of today. I hope we're not. In the event insurance underwriting is suspended on closing date and buyers unable to get insurance, buyer may postpone the closing. You've heard of when there's a hurricane in the box or a tropical storm in the box. Nobody gets insurance. Buyer doesn't want to close without insurance. And the buyer's new bank loaning the money sure as hell ain't going to loan the money with no insurance. And there's really nothing a buyer can do about it. He can't get insurance. Even if you had a time is of the essence provision. With this provision, this gives you that built-in extension. Yes, Mr.
Can the 5 days be crossed out too, or is that like a standard?
Oh, sure, you can cross this out. You could change it to 10 days, or you could change it to 1 day. You know, these are just, you can change any of this stuff. Up above it says extend till 5 p.m. on the next business day. You could say change till 3 p.m. I mean, you can change anything you want. I'm just telling you what the contract says in its built-in provisions, number one. And number two, what most people don't know is in here and what I want you to be aware of when you use this contract and understand what's in there. Because I virtually assure you that somebody will prepare this contract and hand it to you and show you 3 or 4 things, and that's all you'll look at and you sign it. And I want you to be aware of what else is in there and what else you're agreeing to, and of course you can change any one of them, but you can't change them unless you're aware it's in there. So it's a good point to bring it up. Of course you can change these things. Same old thing, cross it out, initial it, just like you did change it, initial anything else. You, of course, may do that, but you wouldn't do it unless you knew it was in here. Okay.
Quick question.
Yes, sir.
A buyer can be assured that once he gets his form that from Florida Realtors that it's always a standard form and like the realtor didn't change anything on there. So you can assume once you understand the form, you can fill those things out without actually reading everything else.
Well, yes. You need to know. For example, if you look down in the, this is what lawyers do. Look down in the lower left. This is the 2010 Florida Association of Realtors form contract. Now, if you get familiar with that form and you know what's in that form, and every time you see something that looks like this, you look down there and see if it says that, you can feel pretty damn good. Let me tell you, this is a nightmare. In the 70s, we have a form contract that is prepared and agreed upon by a joint committee. This is really for residential, but it gets used for commercial occasionally. A joint committee of members of the Broward County Bar Association and realtors who are members of the Greater Fort Lauderdale Board of Realtors. I served on that committee for many years. We draw up a sales contract. And we suggest that it be used in Broward County, and it's got terms in it that are germane to Broward County, but it's a form that we all like better than the Florida Association of Realtors form. I'm not pitching the contract. I've got a story here for you that relates to that. And it says at the bottom, This contract is a form jointly promulgated and approved by the Broward County Bar Association's Committee on Real Estate and the Greater Fort Lauderdale Board of Realtors, copyright with a date. All right. We had a situation in the 70s where somebody took our contract and changed stuff. Got pages, in the old days, without, internet and forms being sent as attachments and stuff like that. Somebody got it reprinted with changes. And that put such fear in every real estate lawyer in Broward County of relying on the form is the form.
Right.
You still skim these things anyway. Things like a built-in that it says seller pays for documentary stamps. That's pretty universal. That's the built-in form in every sales contract. And this thing, the guy changed it to the buyer pays for the doc stamps. But it all looked exactly like the same form. So yes, you can rely on a form, but there have been counterfeit forms done. You said you had a second.
No, so I guess, if it's a case where, you wouldn't be able to then take it to court and say, well, you're under the assumption that this is a standard form and such, each contract, once it's signed, it becomes a contract and it's not so much just a form.
It is. It's not a form. It's not a form anymore.
Right.
No, it's a contract between two parties that just happens to be. They happen to use a form, just like a deed. When you fill in the blanks and sign it and record it, it's a deed. It's not a Ramco form anymore. It's a deed.
Right.
No. So, but what it does do is it helps. See, in commercial transactions, you'll find that every lawyer has his own form of contract that he likes. It ain't this. It's his 20-page form that he knows every word in there and he knows exactly what it says. And when you get one of those in, you got to read every word of it because you've never dealt with this guy before.
Right.
You don't know what his form is, and with word processor today, you don't know what he's changed anyway. If you did a deal with him last year, you don't know that this is exactly that same form. And the one thing I want to tell you, the beauty of this is a pretty good form, by the way. And the beauty of a form is you know that it's going to cover all of the basics. What we tell clients is, even if you read every word in a contract and know what's in there and understand what's in there, where you usually get screwed is by what's not in there. And an important little clause like time is of the essence might not be in there. And you might be counting on, I'm having a grand opening on this date, and by God, we had to have a closing by this day. But it didn't say time is of the essence. So it's one thing to read every word and understand every word and make sure you're comfortable with it. What somebody experienced in the business can tell you is what else should be in there for your protection that's not in there at all. And most lawyers have a buyer's form and a seller's form, and they're done exactly that way. With provisions that are good for the buyer in one and good for the seller in the other, and they start with those, and then you can change them and go on from there. But I mean, you don't give away a lot of seller provisions in your buyer form, and vice versa. This is pretty fair. This is a pretty fair contract, and it's got a lot of good provisions in it. And I suggest to you that if you want to do a commercial deal, and you don't know what else to use, and you don't have a realtor pitching another form to you, or if a realtor has several forms, I suggest to you for a commercial deal, you select this one, not only because we've talked about it and you understand it now, but also it's a pretty damn good, fair form. Yes, sir?
To the extent that someone can actually have the wherewithal to negotiate, oh, I want to change this to this date, doesn't that depend on how much quote-unquote power you have on your side? You know
Sure.
what I mean?
Any negotiation depends on leverage
Yeah.
and who has the bargaining power.
So in an instance where this is off of commercial and real estate, say you go to rent an apartment, you can't really negotiate the terms in a lease.
You can try.
I mean, a rental.
You may have, if you have no bargaining power, I agree, you can't.
Or like buying a car and stuff like that.
Yeah, and if you could realize buying a car, you're probably the only person that ever read that thing. The car salesman sitting there doesn't know what the hell's in there. And no, they're not gonna let you change it. They're not gonna let you change it because their lawyers have approved it. Ford Motor Company lawyers have approved this financing form, and they're gonna tell you, we're not allowed to change it. What that usually means is, we have no idea what the hell you're talking about, and we don't know what it says anyway. But the stock answer is, no, you may not change it. But you can talk them into it, sure.
For the big deals, like 30, 40 million and up deals, do they use this contract form, or the lawyers have their own?
Yeah, I've never seen a $20 million deal done on this contract, but it doesn't mean it couldn't be. There's no reason it couldn't be.
Right. This is standard for like smaller deals, like under 10, 5 million.
I can't even say to you, you know, it's good for a duplex. It would work for a duplex. It would work for a strip center. Would work for, you know, like, for example, if you get into a filling station. Yeah, this might work for the basics of a filling station, but in a filling station, there are all kinds of other dealer agreements that are going on that you have to, you know, Gulf Oil has a right of first refusal and all that kind of stuff. I mean, but there is no reason that you can't use this. I suggest to you that if you're doing a $20 million deal, unless you're really good, you should have a good real estate lawyer. And, but that doesn't mean that this contract is bad particularly if it happened to be vacant land. There probably are not so many confusing concepts that this wouldn't work. And this covers the basics. I mean, this talks about, yeah, we'll prorate rents and we'll do all that kind of stuff, you know. It's just that usually there's so much more going on in a commercial deal than just the basic provisions of what's the price and when we're going to close and where we're going to close and stuff like that. Okay. Now, talk about when are we going to close, where are we going to close, you know, you fill in the blank. Paragraph 5 on the next page. You remember we talked about the financing blank over here in line 16 where you fill in an amount of a mortgage. This is one of the types of things that could come into play for that line about the amount of financing. This is called third-party financing, and what that means is new mortgage, new lender. That's what this is all about. Brand new mortgage with a new lender. Buyer's going to go out and look for a new loan. And what this talks about is all the obligations about the buyer might want to limit what interest rate he's willing to pay and what term he's willing to go for. So we fill in all those kind of blanks. And the seller wants provisions in here that the buyer will diligently pursue the mortgage and will fill out all the applications and do everything that's required. And cancellation is right in the middle. If the buyer can't get the loan, the buyer gets to cancel. Now, it's a little more complicated than that, but that's what this boils down to. And 2 lines under the word cancellation are the 2 buzzwords of what this is all about. Financing contingency. It doesn't say it, but this is a financing contingency. This paragraph says that this whole deal is contingent upon whether buyer can get a loan on the terms stated here. And if he can, great, we have a closing. And if he can't, we don't. And it's just like when you sign a contract to buy a car. Contingent on getting approved for a loan. Can't get approved for the loan, well, you can't do the deal, you can't close. But this is provisions where the buyer will try and the buyer gets his deposit back if he can't. So this is one of the many back doors we talked about in the deal. You might have a huge deposit down, but if you know you can't qualify for a loan, you're going to get it back anyway, what the hell? Next section is all about title. And there are a couple of concepts going on in title. But the first part is where it says seller will convey marketable title by blank deed. You put in here what kind of deed the seller is willing to give. We're going to talk about deeds later, but that's something that parties fight over. What type of deed will you give me, Mr. Seller? Will it be a full warranty deed? Will it be a special warranty deed? Will it be a quick claim deed? Will it be, you know? That's something the parties can fight about, and you can argue over it and fill in the blanks. But you do say here that the seller's title is going to be free of liens, and this part becomes important. Free of liens and encumbrances and restrictions and zoning and all other things and other things that you can fill in here. But you provide here, however, and this starting at line 70, providing there exists at closing no violation of all these things that title is going to be subject to, and most importantly, none of them prevents the buyer's intended use of the property as a what? Now, if you're buying a piece of property and you know you're going to try to build a school there, then you're going to put in there for use as a school. And that means that there will be no restrictions or no zoning or no other matters of record that will prohibit me using the property as a school. Now, if it's going to require rezoning, well, that's different. Then you have to make some special provisions regarding it. But the point is, what you're saying here is, and this is the buyer's clause. This is buyer saying, I intend to use the property for the following purpose. And seller, you are guaranteeing me here there's nothing out there that will prohibit this use of my property. Now, that doesn't mean you're going to rely on that and say, okay, seller said it was fine, that's cool. You're going to go check all that stuff out before closing anyway. But the point is, before going into this deal, you're having the seller swear this property is appropriately zoned for this purpose and may be legally developed or used for this purpose. And if the seller's not willing to do that, you got a problem. Okay, that's real important. Now, Section A, evidence of title. The seller, after you sign the contract, is going to deliver to the buyer some sort of proof that he has good title. You haggle over it here. Is it going to be an abstract? But we don't have abstracts anymore. Is it going to be a change sheet? Is it going to be a title commitment? What is the seller going to deliver to the buyer early after the contract has been signed to demonstrate that the seller has good title and what seller's title is subject to? And there are different customs in different counties for how that's done. And this is a statewide form. And in some places you use an abstract, in some places you use a title commitment, in some places you use an old title policy and a change sheet. But the point is, you specify here now what the seller is going to give the buyer to show that he has good title. And in Section B, after the buyer gets that title information from the seller, the buyer has a certain period of time to examine the title information and determine whether or not the buyer thinks the seller has good title and whether or not the seller has violated this clause up here saying there were no restrictions that said I couldn't use it as a school. And the buyer has a certain period of time to examine that title evidence and write a letter back to the seller saying, here are the following things wrong with your title. Fix them. And this tells the seller you must correct the following things prior to closing, and if you don't, the deal's off. The buyer doesn't have to close. But that's mechanically how you go through this stuff. After you've signed the contract, seller proves he has good title, buyer reviews that proof, writes back and says, okay, your title's approved, or doesn't write back at all, in which case he has said the title is approved, or writes back and says, here's what's wrong with your title. And you may write back and say, you've got 3 liens and 2 judgments, and you got 4 mortgages, and that's fine. But all those have got to get taken care of prior to closing. Okay, there's one other thing the buyer is going to do, among other things, to check out the property, but it's here in the title section, and it's get a survey. And we're going to talk about surveys further in the legal description section. But a survey, everybody knows what a survey is, right? You know, survey is a drawing of the land showing all the improvements. And buyer's going to go out and get a new survey and see during that same time that he's doing the title examination. And if it shows any problems, and it could show problems, it could show the neighbor's house is built halfway onto your property. It could show a fence line problem. It could show utility problems. It could show a road going through the property. You don't know whose road that is. It can show you all kinds of things that could be a problem, and those problems are the same as title defects. And they get raised in the same way as the title objections, where buyer writes back to the seller and says, and in addition to all your mortgages and judgments and liens, you got all these other problems that are shown on the survey. Fix them. Fix them prior to closing, or we're not closing. Okay. And hugely important here is item D. And we talked about this when we talked about easements. We talked about that the most important use of an easement is for access. And you remember we drew on the board a piece of property that's landlocked, and it's got to have an easement to get out. And the most important use of an easement is for access. How do I get to the property? The seller here warrants ingress and egress. Ingress and egress is the same thing as access. Access is the ability to get to a property. Ingress is the ability to get in. Egress is the ability to get out. Ingress and egress equal access. And they are the most important use of an easement. And the seller guarantees here that there is access to the property, that there is ingress and egress. Now, you're going to want to check that out anyway, just like you're checking out everything else the seller is saying. If you're on a public dedicated road, that's cool. If you're not, you're on a dirt road, well, you're going to start checking. Do I have a legally enforceable easement to use this road to have access to get in and out of my property? Okay.
Is there ever a time when a landlocked property is a good thing?
When a landlocked property is what?
It's a good thing.
Is a good thing?
Yeah.
Let me tell you why it's not a good thing. Even if it's a good thing for you, and you know how to fly and you know how to get there, or it's on the water, and you're going to get to it by water, here's where it's going to get you. When you try to sell that property, or you try to get a mortgage on that property, you're never going to find a buyer, and you're never going to find a bank that'll loan you money on it.
Well, the reason I asked, because last week we had came across a property in Jacksonville, like a hospital, where it was mentioned that it was landlocked. Like, we didn't really ask too much definition of it, but it was mentioned that it was landlocked property.
It was mentioned in what sense? You mean the seller disclosed to you?
The gentleman who came to talk to us, who was looking into purchasing it.
And they said that as a positive?
No,
I mean, like, here's all the wonderful things about the property, it's landlocked?
Yeah, it's landlocked. That's kind of what he threw in there.
No, that was different. What he meant was that there's no room for expansion around it.
I'm gonna take a 10-second restroom break, encourage anybody else who wants to too. I'd love to hear how and why.
Okay. So what was you saying?
I think what he meant was that you can't expand. You can only build on that area, because there's no space, all of it's right there.
So it's landlocked for everybody else.
I scratched
Not really. It's the same word, but used in a different way.
I was like, had
Hey, y'all better not laugh at me. You know,
that's a great photo. It's very accurate.
What? Oh, okay. How many days is it gonna
I kept thinking that, but I didn't write it down.
That's what I do for the story. I just start up walking on the floor, my place on the floor.
Honestly,
I do have kids.
Oh, yeah. Wow.
I mean, the truth is that I skimmed over everything. Like, he didn't teach it. No, from another class. So I'm like, that's why I wish I was a contract right now. Oh, see, I know before the real estate class I would. Because if you take like a week, like kind of legal class, it all flows over.
I wish I was doing the real estate exam now.
Are you doing it?
I'm doing it in January. I have to do it in January.
Why? What do you want to do?
All the job descriptions, I love that.
I like what?
For example, CBRE has to most days that I'm looking at.
Gotta bend at the knees. Important.
What?
Just those
Okay,
knees.
just that. Do you want to do
It's on my
leasing?
shoulder.
Like what?
No, I don't actually want to do real estate.
Harrison, that
One
injury.
particular that I am interested in.
Because none of them that I
Your
want to
kids
do
can't go at the rotate all the time.
The one in particular.
Yeah,
You gotta
you
brace
slept on it wrong.
It
Pick up your
has
place.
nothing to do with leasing, but it's one of the requirements.
Whenever you,
What is
But I
you know,
never
where it
exact,
pushes
I have
both.
it anyway, because it only
I'm
comes.
like half doctor, so I can help you out.
More than that.
Yeah, you have to take the class.
Oh,
I-
That's a lot of business.
You
A lot of
get-
business.
It was like,
Yeah, I got the
Yeah,
PH,
they
but it's not the
I
E.
found one the other day, and I was wondering why go close.
I got the PH, it's not the PH.
They're like,
Because they have a simple solution to passing rings,
Yeah.
exam.
I have-
Yeah.
I have a doctor's degree.
I mean, I think at the end of the day, it probably costs me like $1,200.
Yeah, all in.
Everything. Would you agree?
The license.
Yeah.
So you won't have to, you just need to have your license, you don't have to actually, you go to like CBRE, they're not gonna make you pay money.
You don't have to
There's,
take the class, I don't
There's-
think, if you have your master's.
Really?
Not to get your initial license, you don't. I think there are two ways around it.
I called
You
and
might be able to
asked.
say that this is a form of,
One
I already
is
called and
being
asked.
an attorney, and the other, I'm pretty sure if you have a certain number of credit hours. Because I have friends who didn't take classes in a master's program. If you have this, I mean, you can call them. and they'll tell you.
No, I did call and I asked. I said you do.
No, I don't think.
Miss Reed.
Okay, folks, I'm gonna go. I'm hell bent that we're gonna get through this contract before lunch, before 1 o'clock. And,
I don't know.
so,
He also had his undergraduate with a minor, and that's why.
paragraph 7,
It's not.
property condition. Now, this contract says, built in, that it's being sold in as-is condition. And as we're going to talk about later, in the fraud section, the courts will allow you to say the property is in as-is condition in a commercial deal, but not in a residential deal. You can say it all you want to, but it doesn't mean anything in a residential deal, is what I'm getting at. But in a commercial deal, as-is means I, the seller, am not guaranteeing anything. Knock yourself out, as you're going to see in a minute. Check out everything that you want. Make yourself happy. Don't rely on me. I'm not promising nothing, except that I have good title. And you're going to check out whether I have good title or not anyway. Now, this contract gives you two choices of how you're going to accept the as-is property. You're going to say, in A, and I've only seen this ever checked once, buyer has inspected the property and waives any right to inspect the property and accepts it in as-is condition right now. I agree, everything is just fine. You don't know why you would do that. Maybe maybe you've been a tenant for years and you know the property better than the seller does, in which case you're not going to have to check anything out. You already know the property. Other than that, I can't see that making any sense. All deals are done today under Section B. And even a lot of residential deals are done today under Section B that we're going to talk about. And this is really the right way to do deals. It's about the due diligence period, also called the inspection period. And what happens here is buyer has a certain period of time, and of course you fill in that period of time in the blank on line 117. What is that period? To check out everything and to determine, as you see here in line 118, to determine whether the property is suitable in buyer's sole and absolute discretion for buyer's intended use and development as specified in property section above. In other words, where you said, we said for a school, I have the right to check out everything I want in my total discretion to determine whether or not this property is usable as a school, as a buyer. Now, it goes on to say, and I'm not going to go through all these with you because that would take us the rest of the day, but you should read this and think about every one of these types of things and more that you should be checking out. It's a great laundry list of about 6 lines here of things that buyer is approved, all of the following things: zoning, and soil, and utilities, and land use plans, and on and on and on and on. The point is, for that period of time, whatever it is, check out everything. And at the end of that period, make a decision based upon buyer's own examinations. Do I or don't I want to buy this piece of property? In your sole and absolute discretion. And at the end of that period, buyer sends a notice to the seller, either I've done all my inspections, I'm happy, let's do it, or the deal is off. I cancel, your property is not suitable in my sole discretion, and I want my deposit back. Now, contrary to popular opinion, buyer does not have to say why. Does not have to specify what it is he didn't like about the property. Simply, it is not suitable in my sole and absolute discretion. I'm sorry, deal is off, give me my deposit back. The flip side of that is, if buyer doesn't cancel, seller gets to say, I don't want to hear about it anymore. I don't want to hear about it between now and closing, and I don't want to hear about it after closing. You had the right to check out every single damn thing you wanted, and you should have. And if you didn't, don't whine to me about it. Now, in the abstract and the nice world, that's what should happen. What usually happens is the buyer does all these kinds of tests, and then he comes back to the seller and renegotiates with him. Yeah, but I find out the roof is going to be bad in 5 years, and I found out you got a plumbing problem and the air conditioners are going on. I want $7,000 off the price, and you haggle and you negotiate. But the buyer has the absolute right to walk away. That's how deals should be done. It protects everybody. It's the right thing. And it's the fairest thing. You're going to see in a later section, now I'm just going to say it, There's another way of doing this, and we'll talk about it when we get to it. In the letter of intent that we talked about before, you're going to see this specified as an inspection period. Everybody calls it the inspection period. A better term is this due diligence period, because it's the period for the buyer to do his due diligence and check out everything and say yay or nay. And as it says at the end, should buyer deliver timely notice if the property is not acceptable, the seller agrees the buyer's deposit will be immediately returned to the buyer and the contract is terminated. Bill's off, it's over. That period is highly subject to negotiation. It's rarely less than 30 days. It's often 90 days. I've seen them as long as a year, because sometimes buyer was going to have to get the property rezoned. And the buyer didn't want the property unless it could obtain the rezoning. So usually in a situation like that, you'll have a specific paragraph about it. This is kind of a catch-all as to anything that could be, and this includes your environmental inspections, your asbestos inspections, your ADA inspections. I mean, this is all the things you ought to be checking on a piece of property. And checking the leases, checking the terms, checking the strength of the tenants. I mean, I seriously could do this for an hour. All the things you ought to be checking. But after that, don't whine about it. Your deposit is at risk after that, and if you don't close because you found something later you didn't like, you stand a substantial risk of losing your deposit as a buyer. It says at the bottom here there's going to be a walkthrough inspection. That's kind of a holdover from residential deals. That's sort of okay, the day of the closing, we'll all go look at the property and see if anything's changed. That's not real relevant, but it's there. Now, paragraph 8 is important. In a commercial property, between the date of the contract and the date of the closing, this is about how the seller should operate the property. Most importantly, it's about leasing. You got a commercial property, you got 6 vacancies. Do you or don't you want the seller signing up leases for those 6 vacant spaces before closing? Maybe.
Not necessarily.
Maybe if he leases it to his sister for $10 a year for the next 20 years, maybe you don't. So it's something you need to be aware of. And it's a real simple blank here to check, and it's very clear. You ought to check only with buyer's consent. Most big long-form commercial contracts talk about this at length. Talk about leasing between contract and closing, and leasing on the same terms as terms of other tenants with similar deposits and terms and options and renewals and all that kind of stuff. I mean, there's a lot of provisions. And you know, if you're buying a shopping center and you're not going to close for 90 days, there are going to be some tenants that are going to move out. There are going to be some leases entered into. Maybe that's good if they're good leases. Maybe they're leases that you would not have wanted signed up. Maybe you were going to take those 3 vacant spaces and combine them into one and sell it, rent it to a national tenant. And here the seller rented it to 3 different moms and pops for 2 years each, you know? So it's a big issue. This paragraph at least tees up the issue of the business matters affecting the property between contract and closing, how they're going to be handled. And of course, as a buyer, you want to check only with buyer's consent. And as a seller, you may want to check without buyer's consent, because you may not want to have to ask the buyer. So that gets fought over if people read the paragraph. Unfortunately, lots of them don't. Closing procedure in paragraph 9. This just kind of walks through some kind of general stuff. We're going to talk about closings later. Yes, sir.
I had a question on that. How, like logistically, how would that work? Because I mean, if you lease a space, you got broker's commissions, but you're only going to keep the property for maybe 2 more months, or you have tenant improvements for the move-in. I mean, how does it
work? Well, that's why you write those. You write and you talk about those things. That's the point. Because
almost as a seller, you wouldn't want to lease a space if you had to.
Yeah,
pay
that-
commissions and
that's
all
the
that,
whole
and it
problem.
gets, like,
As a
kind of
seller,
prorated out.
forgive me, I thought I would cover that. As a seller, you don't know whether the buyer's gonna close or not. So you don't want to have your hands tied on leasing space by having to ask the buyer. Conversely, as a buyer, you don't want the seller out there willy-nilly entering into bad leases and messing up my property for me for closing. So if you ask me, how does that work? It works either you check one or the other of those blanks, or you have a substantial paragraph that talks about what's gonna happen. And you're right, brokerage commissions are a big deal, because sometimes brokerage commissions are paid or unpaid. Sometimes they're spread, sometimes they're not spread. If it's wonderful that the seller entered into a lease, it sounds great, but he provided in the lease that the brokerage commission is not payable until year 3, and you bought it and then you're stuck with a commission. You know, these things can hurt you. This is a good paragraph to tee up the issue. This is a lousy paragraph to spell out everything. And maybe that's something you'd want to do in an addendum or in a special clause and talk about it, knowing the type of property that you have. I hope I've answered your question. It does not cover all those issues by any means, not even close. Closing procedure. Says we're going to sit down and have a closing, and possession will be delivered to the buyer at the closing. That's pretty obvious, but it often is negotiated, particularly in residential deals. Either the buyer gets in early for some reason, or the seller stays late for some reason, but absent that, possession gets delivered at closing. And this talks about handing over remote controls and keys and all that. A lot of that stuff is not real relevant. But it is important, but they're things that are kind of a given. B, costs. These are recording costs. And this is where I mentioned to you that standard contracts all provide who's going to pay what recording costs, and recording costs can be substantial in a transaction. There's a state documentary tax on a deed. It's 0.7%. You don't need to know this, you just need to know that there's a good sized recording tax that's going to be paid when that deed is recorded. And customarily statewide, that's paid by the seller. But of course you could cross this out and change it. Likewise customary that buyer pay all the similar type doc stamps and intangible taxes on a mortgage. But you could change that. But this provides all of the standards. C talks about who's going to come up with what documents for closing they're going to be required. There's a whole list there of documents that will be provided by the seller. They're all closing documents. We're going to talk about those when we get into closing procedure. But this is who's going to do them. At the bottom is the custom, which likewise that the buyer provides the closing statement. But very often in a commercial property, a lot of the information to go on a closing statement has to come from the seller, because a lot of the information in a commercial closing statement is about leases and about rents and prepaids and securities and stuff like that. So, but this paragraph outlines all of those things. You usually wouldn't change it. D talks about prorations. So we're going to talk about those when we go on closing statements. But prorations are financial matters that cover a term either beyond closing or prior to closing. In other words, the real estate taxes. Real estate taxes are for a whole calendar year. You're probably not going to close on January 1 or December 31. So either the seller has paid the taxes forward for the buyer and should have a credit, or has not paid the taxes for a period and there should be a credit to the buyer who's going to have to pay the taxes later for a period the seller has owned it. That's a proration. You adjust those things on a closing statement. You adjust utilities. You adjust rents. You adjust all of these items that cover period. Rents, for example, a month's rent. You close on the 15th. What about that month's rent? Well, if the seller's already received it and the buyer's closing on the 15th, the buyer should get a credit for that 15 days rent because the seller kept the whole month's rent. And vice versa. What if somehow the buyer was going to collect that rent, but the seller was entitled to 15 days of it? So you adjust all those things on the closing statement. That's what prorations are. And we'll talk about those in closing statements. There's provisions here about special assessment liens. These don't happen very often, but they do occasionally. These are like liens where the city has got a lien on there for installing sewers or for paving the roads or for putting in sidewalks. Who's going to pay it? You got rules for that. That's good, because if you didn't, you're going to get in a fight over this. I want to talk about FERPTA at the bottom of the page. Section F, FERPTA is the Foreign Investment and Real Property Tax Act. And I just want you to be aware of what this is. It's a biggie here in South Florida. It ain't as much of a biggie in Idaho. But in South Florida, where you have foreign investors buying real estate, it comes into play a lot. And most particularly, foreign sellers selling real estate, because this is all about whether the seller is a foreign person. This is not about whether the buyer is a foreign person, it's about whether the seller is a foreign person. And here's what's going on. IRS has made a policeman a tax collector out of all closing agents, title companies, and lawyers, and buyers, believe it or not. What this is about is, if you're buying a piece of property from a foreigner, a person who does not have a U.S. tax-paying identification number, IRS requires you as the buyer, or your closing agent, or your lawyer, or somebody in the transaction to withhold 10% of the purchase price. Not give that 10% of the purchase price to the seller, but give it to IRS. What's going on here is IRS is worried about foreign sellers making money and capital gains in real estate and not paying taxes on it. So they're making you the policeman to make sure that you set aside 10% of the purchase price and send that money to IRS. Don't give it to the seller. Here's what's important about it. If you don't do that, then you are responsible for that 10% of the purchase price. Think about that in a $3 million deal. You are required to withhold $300,000 of the seller's money and send it to IRS. If you don't, and if that seller stiffs IRS and doesn't pay his capital gains tax, you are liable for the seller's capital gains tax up to that $300,000. Now, you can talk for days about the exemptions and the ways to get around this. And what it boils down to is, you as buyer or closing agent or lawyer obtain from the seller a sworn statement that the seller is not a foreign person and that the seller has a U.S. taxpayer identification number, which is a federal ID number, either a social security number if it's an individual, or a federal ID number if it's some sort of an entity. And if you get that statement from the seller, you're entitled to rely on it, and then you don't have to withhold the money. But if you don't, and if the seller does not pay his gains tax, you're liable for it. So this is huge. And this is, it's a strange thing that our country did. In the 60s and 70s, we encouraged all these foreign buyers to come up and buy real estate. And we said there will be no capital gains tax on you sellers. Please come invest your money in our country and you can make all the money you want and take it back home and there'll be no capital gains tax and this is great. So they did. And then in, I've forgotten what it was, early 80s sometime, Congress said, well, we were just kidding. Now, when you sell that property, Mr. Foreign Seller, you're going to pay the same capital gains tax that an American citizen pays. You're going to be required to file an American tax return and pay capital gains tax. And of course, a lot of them said, yeah, that's cool, and didn't. And then Congress quickly came back with this act to help collect it. Let's make every closing deal with this issue and determine whether or not you have a foreign seller and collect money and send it to IRS. Now, there are ways to get exemptions, and a foreign seller can apply prior to closing for an exemption certificate, and of course, if he gives you an exemption certificate, then fine, you're exempt. And there are ways in certain size residential deals that you can get around it, but it's a little scary. On single-family residences, there are a few exemptions. But overall, if you're dealing with a foreign seller and they can't give you this statement at closing with a social security number or a federal ID number in it, and you better see to it that the money is withheld, because the buyer and the buyer's agents and the closing agents are all liable for this jointly, up to 10% of the price. And that could be a lot of money. This section there says, just tells everybody, we're going to comply with this law. And Mr. Foreign Seller, 10% of your proceeds is going to be withheld. And what it does also is eliminate the right of a seller, the right. Eliminates the right of a seller to come to closing and say, hey, I'm not doing that. You can't do that to me. Yes, you can, because the contract said we're going to. And a lot of sellers get really bent. And sometimes there isn't 10% in cash on the table. That gets really hairy. What happens when there's only, in our $300,000 situation, after you've paid the brokers and paid off all the liens and stuff like that, what happens if there's only $200,000 available, but $300,000 has to be sent to IRS? Well, IRS has provisions for all that kind of stuff. But anyway, it's a biggie. It's a biggie in South Florida because you're often buying from a foreign seller. This is not turned on whether it's residential or commercial property. This is real estate, period. Okay, escrow agent. Paragraph 10 on page, I've lost my page. There, page 5. Somebody held that deposit that we talked about, all these additional deposits, initial deposit, additional deposit, etc. That person's called the escrow agent. There's a good chance that person's going to get sued, because the buyer and the seller are going to get a fight over that deposit. And when they do, they're both going to name the escrow agent. And you find that that's why an awful lot of realtors today are no longer willing to be escrow agents. Traditionally, it was always the real estate broker. But of course, there isn't always a real estate broker in a deal, but traditionally the broker always wanted to hold the deposit. This is how I'm controlling the deal. I'm driving here. I got all the deposit money. This is great. Until they start getting sued. Because what happens is, when the parties get in a fight, the seller thinks the buyer's defaulted and says, Mr. Broker, give me the deposit. The buyer says, no, the seller defaulted, Mr. Broker, give me the deposit back. And when they sue each other, they both sue the broker too, because that broker's got the money. So this is whoever's got the money. Realtors like it less and less. Title companies will do it. Often it's one of the lawyers for the parties. But everybody always worries when it's the other guy's lawyer, because what if he goes to Paradise Island and gambles the money away and it's gone, you know? So I mean, there are a lot of fights over who's the escrow agent. But once you've resolved who that poor SOB is going to be and who's going to be holding the money, these are the provisions that protect the escrow agent. To collect his attorney's fees and costs when he gets sued, but that doesn't make it fun. And give him the right, when he's had enough of this crap, to go to court and file an action called interpleader where he says, Your Honor, here's the money, you take it. And let these two guys fight over it, and you hold the money, but I'm out. And that's all the provisions here to protect the escrow agent for when he gets sued and how to get out of it. Yes, Mark, I'm sorry, I wanted to finish that thought before your question.
I know on the residential transactions, the buyer can choose the escrow agent. Is that for so, and does that relate to commercial as well?
Well, the buyer specifies who he wants his escrow agent to be. The seller does not have to agree to that.
Okay.
What I'm saying is that gets negotiated. Back on the first page where he filled in the name of the escrow agent, you'll often see people crossing that out and changing it. No, I don't trust your lawyer, my lawyer. And sometimes, no, we don't trust either of the lawyers, because lately that's getting to be a scary thing. Let's pick some title company. That ain't the best either sometimes, you know, but it is subject to negotiation. But usually in standard procedure, as I know you know, Mark, the buyer writes a check for his additional deposit. He writes that check to whomever he thinks the escrow agent is going to be, usually a realtor. So often his realtor, but sometimes that realtor right away says, not me, I don't want it, you know, write it to the other realtor. But that initial deposit check may have to change if the parties have not agreed that the payee on that check is in fact who the escrow agent's going to be. Okay. Cure period is not really important. It basically says if anybody's in default, you got to give them an opportunity to cure their default. That's good. Return of deposit says, you know, if you're entitled to your deposit back, you get it back. I want to talk about paragraph 13, default. This talks about, we talked earlier about defaults under a contract, and we talked about remedies under defaults. And this paragraph talks about what if the seller defaults and what if the buyer defaults. Now, we've already got a signed contract and we're heading towards closing and something goes wrong. Okay, in the event the sale is not closed due to default of the seller, okay, the seller. Seller changes his mind. To hell with you, I'm not selling anymore. Not selling. Okay? It talks about other than an effort to clear title, but we're not going to go there. Buyer may either receive a refund of his deposit, but that obviously means the deal is off. Or, and this is the biggie we talked about before, seek specific performance. The important remedy. Force the seller to close. Your Honor, make him close, and the courts will do it. Make him give me a deed, make him come to closing, order that there be a closing. Specifically perform the contract. That's an important remedy because it gives you the benefit of your bargain. If you get your deposit back, remember that you spent months and tons of money as a buyer. You've ordered surveys and environmental audits and engineers and architects and you've done all that kind of stuff, and what, I'm going to get my deposit back? That ain't great. Specific performance, make the seller close. That's your big remedy. Goes on to say, and if the buyer asks for his deposit back, the seller is still liable for the commission. Well, that's a wholly different issue. But that's in there. But we'll talk about commission stuff in the next chapter. Okay. Now, if the buyer doesn't close, if the buyer refuses to close, you know, for no reason whatsoever, not that he canceled because he didn't like the property, not that he didn't get his loan, all these other contingencies we talked about. If those are contingencies, if he cancels, he gets his money back. But if he has no excuse and you get to closing and he just plain doesn't close, okay, seller may retain the buyer's deposits. Follow me here if you would, line 222. As agreed upon liquidated damages. We talked about liquidated damages before. What we're saying is the amount of those deposits are liquidated damages that we've agreed in advance that that's going to be the amount of the damages. They will be consideration for the execution of the contract and in full settlement of all claims upon which this contract will terminate. So what that means is, seller, you can't go after the buyer for any more money if you're killing the deal here. Remember that in that case, the deal's off and we're keeping the buyer's deposit. Or, number two, seek specific performance. Again, the important remedy, make the buyer close. Now realize, that's easier said than done. It's one thing to make a seller close. The court can order the seller to give a deed, and if the seller doesn't give a deed, then the court can actually convey the property. Making a buyer close is a little tougher. Making him come up with the money, well, probably not closing because he doesn't have the money. That's the best reason. Well, it's very hard for the court to order him to close. If you don't have the money, you don't have the money. But the important thing is, you can obtain, under this contract, an order ordering the buyer to close. Now know, if you will, sophisticated buyers and their lawyers will immediately cross that out. If General Motors is the buyer and they have plenty of money, the most they're ever going to let you do is take their deposit. So immediately, buyer's lawyers cross out specific performance there on line 224 as a remedy against the buyer. And if you're the buyer, and unless you want the court to order you to close, cross it out. If the philosophy here is, I'm putting up a deposit and I'm willing to risk losing my deposit, but that's all I ever want to lose, you cross it out as a buyer. Otherwise, the court can order you to close. Okay. And then it goes on to here say again, or the broker's going to have some of your money. But that's not really relevant. We're talking about the rights here between the buyer and the seller. Section 14, we talked about this earlier. Excuse me. Prevailing party attorney's fees. If there's litigation, the winning party gets to recover his attorney's fees and costs from the losing party. It's fair, it's right, it's what it ought to be. If you're right and you win, you shouldn't have to pay your own lawyer. But it's a gamble. When you choose to sue somebody, you better be right, or you may end up paying both lawyers. Okay, something about notices, how you give notices. You can read it or not, it's not important. A bunch of disclosure junk that are mandatory, state laws and regulations about garbage that has to be in the contract, like radon gas and stuff like that. Risk of loss, paragraph 17 in the middle of the next page. This is where we talked about what happens if something physical happens to the property between the date of the contract and the date of closing. Fire is a biggie. The other casualty has always been a biggie down here and is becoming a biggie other places in the country with floods. What happens if a natural disaster damages the property prior to closing? Contract says that's seller's problem. And that's what you normally would expect it to be, that it should be the seller's problem. However, the law would have said otherwise. Common law said from the date of the contract forward, it would have been the buyer's problem. It was a stupid rule. It didn't make any sense. If it's, usually the seller still got occupancy. So the seller ought to bear this risk. So what it says is the buyer can cancel if something like that happens. And we do have problems like that during hurricanes. Hurricanes happen and people have contracts outstanding. Alternately, rather than canceling, buyer can say, or I'll close. Give me the insurance proceeds. Give me the money payable by the insurance company and I'll take the money and I'll buy the property. Buyer's option. And then the other one talks about condemnation. That's not going to happen very often, but you know, what What if after you sign the contract, State Road Department comes along and says, and I want another 10 feet of right of way in the front, and I'm gonna pay for it. Is the deal on or off, who gets the money? That's what this is all about. Paragraph 18, we talked about assignability. Can you assign the contract? Now, people fight over which block you check here. Is not assignable or is assignable. We've talked about who's on which side here. Buyer wants it to be assignable, seller doesn't want it to be assignable. Buyer usually checks is assignable, seller usually comes back and crosses it out and says it's not assignable. Now, the first line though, contract may be assigned to a related entity. What that's about is this. If I sign the contract as a buyer, I have the absolute right to assign this to my corporation, a related entity, an affiliated entity. Usually this happens with big companies that form a separate entity for every deal. So Arvida will sign the contract, but they'll form Arvida Happy Acres LLC number 3 to close the deal. And they have the right to assign it and close. And then you deed to that entity. That's an assignment to a related entity, and that's fine, and that makes good sense. But other than that, where we're talking about a real third-party assignment, buyer wants it, seller doesn't want it, you fight over what goes in the blank, but it's there, and at least it tees up the issue, and you need to be aware of it. And that's why we talked about don't let, if you're a seller, don't let somebody write his name as a buyer, comma, and or assigns, because that means the contract's assignable. Basically says you don't even know who the hell the buyer is, you know? It's not a good thing, and a lot of people do it. And this clause should take care of that, and you don't have to do that. Yes, sir?
If the clause is there, but he or she still signs my name and assignee, what happens then?
I would cross, if to be doubly safe, I would cross it out, and I'll tell you why. You remember our earlier rules of construction over what controls? That would have been a typed-in thing, and this would have been a form thing.
Gotcha.
So that would control. I'd get it out of there. If you're a seller, get it out. It's not good business. It really isn't. Brokers. This is basically where you fill in what's defined here as the seller's broker, but we all know that means the listing broker. And you go through blanks here of who the broker represents and who's going to pay them and how much they're going to get paid, and on the next page you do the same thing for what's called the buyer's broker, that we call the selling broker. This is the broker that really found the buyer and brought him in. It's called the selling broker, buyer's broker. And you fill in the same thing. Whose broker is he? Who's going to pay him? How's he going to be paid? Da, 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 da. And then there's the provisions in there about the brokers. Now, I'm going to take a couple extra minutes because I want to finish this thing, and we'll adjust the time at the other end, but I want to get through this contract. Section 21 here says there may be some optional clauses coming up, and we're going to roar through those in a minute. If you use any of the optional clauses on this pre-printed addendum, you're supposed to check the little box here to tell everybody, yeah, we really mean it. 22 is where you add in additional stuff. Line 321, I think is the most important line in here. This is intended to be a legally binding contract. If not fully understood, seek the advice of an attorney prior to signing. This is the broker telling you who prepared this thing. If you don't understand, get a lawyer. And I'm going to say to you that I used to tell clients, the best thing a lawyer can do for you is in the contract. After you've already signed the contract and you bring it to the lawyer, well, his hands are pretty damn well tied. You've agreed on everything already. So, if you think you're going to get a lawyer in the deal, you think you might, for God's sake, get him before you sign the contract, not after. Because he can't do a hell of a lot for you then. You've already agreed to 99% of what's going to happen. And he can't change that for you. So bring him in early, or in my opinion, don't bring him in at all. Or if you have a problem, bring him in. But, okay, now, Next page is the signature page. And I told you there were 3 most important things in any deal. And number 3 is getting the signature of the seller correctly. Get binding signatures. We're going to talk about a little further in a minute. But the 3 biggies are get the parties right, get the property right, and get this thing signed properly. Because if it isn't signed properly, it's worthless. If it's a corporation and you have it signed by the janitor, it ain't binding. You're looking for a corporate officer. In an LLC, you're looking for a member, the managing member. In a limited partnership, you're looking for the general partner. In a corporation, you're looking for an authorized officer, president or a vice president or the CEO, not the chairman of the board. Get a proper corporate officer to sign the contract if you want it enforced. And if you don't want it enforced, don't bother doing the damn thing. The whole reason for having a contract is to make it enforceable. Now, there are 3 pages here of optional clauses that you might want to insert in the contract. We're going to roar through these because these are maybes. I'm just going to tell you quickly what they are. This is this thing at the top of the page that says commercial contract optional clauses is 3 pages long. And these were that list of optional clauses that you saw over there before the get a lawyer clause. And you initial these things if you're using it. But and you go X the box back on the prior page. Arbitration. This contract says if you get in a fight, it talks about going to court. Now, if you don't want that, and if you want to have mediation or arbitration instead, this is where you indicate it. This clause is about arbitration. You could likewise provide mediation. Remember we talked about alternative dispute resolution, mediation, arbitration, instead of going to court, all the benefits. All that stuff you saw, that we saw in the contract before, that was in a residential contract. This is not a residential contract. This is a commercial contract. It doesn't have mediation and arbitration built in. It has prevailing party attorney's fees, presumes you're going to court. But if you don't want that, and you want to put in mediation or a separate clause in arbitration, this is where you write it up. Section 1031 exchange. You may recall, I think it was in leasing somewhere in left field, there was a paragraph about 1031 exchanges in the middle of a section of the book that had nothing to do with them. This is what they have to do with. Simply, and this is the subject of a whole 5-day course, how these things work. But simply there is the ability of a seller to defer his capital gains taxes by doing something called a Section 1031 exchange. If you think you want to do that, and even if you're a seller, and even if you don't know whether or not you want to do that, check this clause anyway because it gives you the right to do it. It doesn't do any harm. It ought to be in every contract to give the seller the ability to do a 1031 exchange if he wants to. What it does simply is defer a seller's capital gains taxes. And it's complicated. It's got rules about you go out and you buy another piece of property in a certain period of time and you give your basis transfers to that property and you pay your gain when you sell that one, or you do that again and again and again. You keep deferring the payment of your capital gains tax. This does not hurt the buyer. It gives the seller a right to not pay capital gains taxes now, to defer them till later. And if you're a seller, X this now so it's in the deal, and then go talk to your accountant or your lawyer about, is it a good idea, should I do one? But there's no reason not to have it in there. Now, property inspection and repair, this number C. This is the way we used to do deals. This is like high school. This is a silly way to do a deal. What this is about is, this is condition of the property. This is, buyer's gonna have inspections, and if buyer signs something wrong, the seller has to fix it, up to certain limited amounts. Now realize what this does, and this is why this is so silly. If you provide that if the buyer finds things wrong with the property, up to 2% of the price, and the seller has to pay to fix them, what's the seller gonna do? Seller's gonna add 2% to the price, because he knows damn well the buyer's gonna find something wrong. So these clauses let buyer get inspections and make seller fix whatever the buyer finds in his inspections. And buyers can keep getting inspection after inspection until they find somebody that finds something wrong to make the seller fix it. There is no inspector that can't find enough things wrong to fix up, to hit whatever limit it is that the seller agrees to pay her. And you force a seller to add that into the price because he knows he's gonna get nicked for it. But if the buyer insists on doing that, the buyer says, I want to know that I'm going to get a property that the seller is, that everything is perfect and everything works right, then you use these clauses. And down in line 39, structural repair limit. Buyer checks out all this stuff, and the seller has to pay up to blank % of the purchase price, structural repair limit. So if you fill in 1%, seller just added 1% to the price because he knows you're going to find it. And if he doesn't, then the buyer can cancel. Same thing on environmental. Buyer can have environmental inspections, seller has to correct it. That's terrifying. The cost of, in this, because this one doesn't have a cap, the cost of fixing environmental problems can vastly exceed the value of the property. Sellers should never agree to this. And then we have one about termites. Termites doesn't happen very often in commercial property, but here's all about if they're termites, seller has to fix it up to a certain amount. So that's a different way of doing it other than saying, buyer, do all your inspections, cancel or don't. This is a way of saying, buyer, have your inspections, and seller has to pay for it. But seller's going to add that to the price because he knows you're going to find stuff wrong. Okay. There are paragraph D here is about seller representations, where you want a seller to represent the income and expenses of the property. You may want seller to guarantee a gross rent roll of $8. Or you may want seller to guarantee an expense amount of such and such, so that you know what the net income is. This is the clause that does it. You fill in the blanks where the seller guarantees those numbers. You can fill in section E on sellers warranting a whole bunch of things about the property. But I ask you, why would a seller want to do that? If a buyer fills this in, the seller's just going to cross it out. And of course, if that happens, then the buyer is going to say, well, that's a red flag. Why isn't the seller willing to guarantee all this? You're not willing to guarantee all this because stuff happens. And you check it out, you make yourself happy. Don't make me be the guarantor of all this. Coastal construction control line is a tiny thing that is not, it's oceanfront property and high tides, and you can't build outside the high tide line and all that stuff. It's a disclosure you have to put in there if you have oceanfront property. Flood zone, yeah, what if the property's in a flood zone? Cap the amount of flood insurance. Seller financing and existing mortgage, these are two biggies that I want to talk to you about, that we did talk about teeing this up earlier. Remember, we talked about the clause of what's going to be the amount of the financing in the deal. What's the amount that's not cash that the buyer is going to come up with, that's going to come from some lender somewhere. Now, in that paragraph at the top of the second page, we talked about that was new mortgages. The buyer is going to go out and get a new mortgage from a third-party lender like a bank. In paragraph H here on line 104, this is seller financing. This is what's called a purchase money mortgage. A purchase money mortgage is a mortgage from the buyer back to the seller for a portion of the purchase price. It's a brand new mortgage, but the seller's holding it. You fill in all the terms here. Really what it boils down to. Fill it out, fill in the terms. What's the interest rate? What are the payments? You know. Or maybe, and this is just finally becoming maybe again. This is the way all deals were done for life up until maybe about 1980. Existing mortgages. It used to be that if the seller had an existing mortgage on the property, the buyer would take over that mortgage. That was called assuming an existing mortgage. The loan stays on there, you sell the property, the buyer takes over that mortgage and starts making the payments. Okay? Well, lenders all figured out this is not a good thing. We could be making brand new loans and earning new points. When a buyer takes over an existing mortgage, the lender gets maybe a little transfer fee or something, but he doesn't get new points, he doesn't get a new loan, doesn't get a whole new closing, doesn't get to bump the rate to today's rates. So for years, lenders had put clauses in mortgages that say this mortgage may not be assumed. But the courts never enforced them until the 1980s. Starting about the 1980s, the courts all said, yeah, that's true. Loans may not be assumed without the lender's consent. Just lately, forms are starting to provide that loans can be assumed by a buyer. Now, very stringent requirements where the lender checks out the financials of the buyer, checks out his capabilities, charges transfer fees, but it is now feasible again. And it's even feasible that there could be a second mortgage on there. As you see, this thing talks about a first mortgage and a second mortgage, that the buyer will take over these mortgages and just pay the difference in cash. And that's called an assumption of a mortgage, an existing mortgage. But those were the three ways of financing a deal. They go back to that blank on the first page that talked about total